Welcome, welcome. I'm glad everybody's here today. I was once emceeing a Federal Bar Association lunch, and there was a gentleman, there was a federal judge that was going to introduce our speaker and award winner. So I was emceeing, so of course you've got to introduce the federal judge, Art Tarnow, and you got to hum a few bars about him, introduce the introducer. So I had to come up with a whole introduction and keep it brief, and I went through all of this. And this is Art Tarnow, who will introduce our guest. And Art Tarnow comes up and he says, "I introduced John Bursch." And that was it. I'm like, okay. John Bursch, his introduction would take longer than his remarks. And I think you all know him, and we're so happy to have you here today, and honored, really. So
thank you.
I give you John Bursch. Thank you for being here.
Well, I'm super excited to be here. As I was just starting to say to someone before we were getting moving here, that God really blessed this opportunity because I almost didn't make it. I was in D.C. yesterday, and I have a son, daughter-in-law, and granddaughter who live just outside of D.C. And so I always take the American Airlines 10 p.m. flight back to Michigan. And at 6:30 p.m. last night, the flight was canceled. And so I immediately started looking for options, and there were no flights last night or this morning that would have gotten me here in time. But God intervened, and I was able to get a seat on a direct flight to Detroit, rent a car, and drive home last night. Got home about 12:30, and that resulted in this. So I'm really grateful to be here and to see so many friends here too. So what I thought I would do is talk for about 20 to 25 minutes kind of about the current state of religious liberty, both at the U.S. Supreme Court and what's happening here in the Michigan courts, the federal courts specifically. And then I hope we can just have a pretty broad conversation about stuff. Happy to take comments, to hear questions, just whatever you want to talk about, I'm happy to talk about. In my job at Alliance Defending Freedom, I work primarily on pro-life, free speech, and religious liberty cases, so this is a space that I'm in all the time and love chatting about it. I am going to start, however, with a case that's not religious liberty related specifically because it just came down this morning, and that was the U.S. Supreme Court's 6-3 decision in Scrimetti, which was a great win for those who believe that God created us male and female. The case involves Tennessee's law, SB 1, which prohibits the use of puberty blockers, cross-sex hormones, and surgery for minors who have gender dysphoria. And the state based its law on substantial science that comes primarily from Europe and not from the United States. In countries like Sweden, the UK, Denmark, there's a few others. They were kind of the pioneers in the so-called gender transition procedures. And after looking at the data over a 20 to 30 year period, they decided that it wasn't actually helping anyone. That at best it was a net neutral, but more likely kids were being harmed by this. And the thing about these European countries, not only were they the first adopters, and so they have a bigger history with this than the American medical system does, but they also have socialized medicine. And so they have records where they can follow kids from birth until they pass away. And so in the United States, if say a 14-year-old goes to Planned Parenthood and says, "I'm transgender, I want cross-sex hormones," and they give it to her, they have no way to track that person. They may never talk to her again. We have no idea what the outcome is. And so when you see U.S. studies, and I use scare quotes around studies, they're almost always self-selected. There's always low response rates. They're not studies that actually give us any meaningful data. Because they can track everyone from cradle to grave in Europe, we know what happens to kids when they have these interventions. And in every one of those countries, they have completely shut down these procedures, except in very small experimental studies, and that's it. We know that the American Medical Association and others here in the United States take a different view on all that, and so that was the science that the ACLU was pushing in this case against the Tennessee law. The Biden administration famously jumped in on the side of the plaintiffs in that case. It was actually their cert petition that got granted. When the Trump administration came in, they changed position but told the court to go ahead and decide the case anyway, and they did. So the two primary arguments that were rejected, first, the ACLU said that the law discriminated based on gender identity, and the court said it did not. Second, they said it discriminated based on sex. The court said it did not. In both instances, the court said what this law does is it differentiates based on age, those who are over 18 and under 18, and also the procedure that's being requested based on the diagnosis. And that, this wasn't in the opinion, but to help you understand it, it makes a great difference to the risks and benefits of say a mastectomy if a 16-year-old girl has breast cancer as opposed to wants to look like a boy. And so concluding that there wasn't any discrimination under either of those protected classes, the court said rational basis applies, and Tennessee's law easily survives rational basis. Now, the court did not specifically say that there is no class of transgender people protected by the Equal Protection Clause, so that's something that's saved for another day. They also did not say anything about the meaning of sex in the Equal Protection Clause, akin to what they did in Bostock. That's also important because you have cases like the Ninth Circuit's decision in Hecox, one of the women's athletic cases, where they said that under the Equal Protection Clause, sex, since 1868, means not only biological sex, but also sexual orientation and gender identity. That question hasn't been resolved. But Tennessee's law has been upheld, and there are 26 states total, including Tennessee, that have laws like this. Now, the one issue that could be remaining is whether there is a parental rights claim. That was one the plaintiffs brought. The Supreme Court did not address that claim. They did not grant it when the petition was granted. It was a question that Justice Barrett brought up at argument to make clear that no one was deciding the parental rights claim. But I don't think those claims are going to be successful either, because the courts have consistently held that as adults, we don't have a fundamental right to demand experimental and risky treatments that the government has prohibited. And if we don't have that right, then we don't have the ability to demand that right for our children either. The Ninth Circuit has already held that in a very different context. I think it's unlikely that there's going to be any traction for that. So that's a great win for protecting our young people and the whole notion of human anthropology. Yeah, so way to go, justices, on that. The 6-3 lineup is exactly what you would expect it to be, so I won't spell that out. So talking about religious liberty at the U.S. Supreme Court, we're living in really unprecedented times. Unprecedented in the number of cases that the court is taking, and also the number of cases that they are ruling in favor of religious liberty plaintiffs. I haven't updated my math, but like a term or two ago, it was something like 24 out of 25 cases had gone in favor of the party that was advancing religious liberty protections. I think Locke v. Davie was the only one in the last 20 years or so that went the other way. And this term is shaping up to be no exception to that. Now, the good news is religious liberty rights are prevailing at the Supreme Court. The bad news is that we have so many of these cases because we also live in a time of unprecedented government persecution where officials at the federal level, the state level, and even the local level, whether that be county commissioners or prosecutors or school board members, absolutely at the school boards, are persecuting religious believers, people of faith, in ways that they haven't in our country. If you think back as recently as the 1970s when the Supreme Court decided Roe versus Wade, there was an immediate response to that at the federal and the state level to offer religious liberty protections to medical providers so that they wouldn't have to participate in abortions that violated their deeply held religious beliefs. And today, we have law clinics set up at law schools and the ACLU and all these other groups trying to strike down religious exemptions, and they call them licenses to discriminate, which is an absurd interpretation of the Free Exercise Clause. So I'm sorry that we're here, but I'm glad that the cases are going so well. So this term, the one religious liberty case that's already been decided is the Catholic Charities case. I hope everyone was following that. This is one of those cases where the Wisconsin Supreme Court decision was so bad, you can't believe that it actually happened. And it was necessary for the Supreme Court to make a merits case out of this. In Wisconsin, as in every state, they've got a workers' compensation system, and you have to pay premiums into that. So if you've got an employee who needs to draw from that system, they can get those benefits. And they disqualified Catholic Charities from its religious exemption. And well, what's that about? Well, the state, like every state, has religious exemptions for these programs so that churches and other religious organizations don't have to participate in them if they don't want to. So why wouldn't Catholic Charities qualify for that? The Wisconsin Supreme Court said they weren't religious enough. The problem is when they were working with poor people, they weren't proselytizing to them. And any secular organization can do that kind of social work, giving out meals, helping with housing problems, helping connecting them to government resources and things like that. There's nothing inherently religious about helping the poor, even though it was the church that created every system that we have today that helps the poor. Just kind of leave that aside. And so that was a close decision. As soon as it came out, everyone immediately circled that and said the Supreme Court is going to have to take this, and they did. And if you had on your bingo card that Justice Sotomayor would be writing a unanimous opinion in favor of religious liberty this year, then pat yourself on the back, because she is the one who wrote the opinion. And it wasn't difficult for her to write. What she said is that when the government discriminates between different religious denominations because of the way they carry out their faith, that violates the free exercise clause. And you can't take Catholic Charities and put them aside of another religious organization that maybe does more proselytizing in the social service work that they do and say they get the religious exemption, but Catholic Charities does not. That's a flagrant violation of the First Amendment. So that was unanimous, very easy. The other religious liberty case that's pending, I'm not sure is going to be unanimous, but in some ways I think it's just as easy because of the facts. And that's the Mahmoud case. And this is the one that arose in Maryland. In their public school system, they've adopted this LGBT curriculum that pervades every single aspect of the programming. Every state has a sex education program with a matching statute that allows parents to opt their kids out of that if they want to. And so the workaround in states like Maryland and California and Washington and Hawaii is that they don't put all the LGBT indoctrination for kids in the sex education curriculum. They put it everywhere. And so the evidence in this Mahmoud case is that children as young as 4 in story time were being read stories encouraging same-sex relationships and identifying as a gender that's different as your sex. And there was a coalition of parents from a broad variety of different faith traditions, Muslim as well as Christian as well as Jewish, who said, we don't want our kids to be exposed to that. This is dangerous and harmful to them, and it violates our religious beliefs. And so when you think about religious liberty and public school curriculum, there's already an immediate tension. Because if religious parents can come in and say to a school, I don't want my kids to learn these 20 things, and you've got hundreds of families coming forward to do that, logistically it makes it very difficult for the school to provide a general education to everybody. Like what do you do if someone says, well, under my creationist religious beliefs, I don't believe in evolution. Now you've got separate science classes for secular and religious kids. It can get messy. And the oral argument exposed the difficulty of trying to resolve that problem. But this school has an exemption policy in place for secular students that makes the legal question easy. If you're in this school district and you're an atheist and your child is participating in the choir, say in middle school, and that choir is singing a song and the word God is in it, like, pick any one of dozens of Christmas songs, and you don't want your child to sing about God, they have the right to opt their kid out of that song or out of that choir class until they're doing non-religious stuff. And it's facially discriminatory to say that you can have an exemption for that, but not to exempt your 4-year-old from the puppy book about LGBT relationships. And so that decision will be issued by the end of this month, but I expect that it'll be a fairly narrow one. It'll be a win for religious liberty, almost certainly. But it'll be on the ground that you can't give secular exemptions but not give religious exemptions. And so that non-discrimination principle, very similar to the Catholic Charities case, makes that one fairly easy. The third religious liberty case that the court had was one that ADF was working on. I was intimately involved in this one. And unfortunately, it was a decision that came out with a 4-4 divided vote. And that was the case involving Attorney General Drummond in Oklahoma and a Catholic public charter school, what would have been the first religious public charter school in the country. Justice Barrett was recused from the case, which is what allowed the court to have a 4-4 split. We don't know exactly why because she hasn't given her reasons. The suspicion is that she has a close personal friendship with Nicole Garnett, a law professor at Notre Dame who used to be her colleague. And Nicole was the one who years ago first came up with the scholarship for this idea. She worked very closely with the folks in Oklahoma, the 2 dioceses that set up this Catholic online charter school. And so we suspect that at some point along the way they had a conversation about the case and she felt she had to recuse. But we're definitely going to be trying to bring other cases up where she's not recused to have the court take a look at this again. Because if you think about the legal issues that were at stake, they really shouldn't be complicated either. We have this trilogy of U.S. Supreme Court cases in Trinity Lutheran and Espinoza and Carson v. Macon, all in the school funding context, where the court has laid down a bright line principle that if you have a government benefit program, you can't open the doors to everybody and say, oh, unless you're religious, don't bother applying. In Trinity Lutheran, it was the playground resurfacing. In Espinoza, it was a scholarship program. And then in Carson v. Macon, it was Maine's town tuitioning program. In each one of those, they said if you were religious, then don't bother applying because you're not eligible. So the same thing is true of charter schools. In the 47 states that have charter schools, as well as at the federal level where we have a federal charter statute, each one of them says anybody can apply to have a charter school unless you're religious, then you're categorically barred. And so that would seem to violate the principles of the trilogy. And so the question then comes down to whether a charter school is an arm of the government. either whether it is literally the government itself because it's denominated public school, or whether it carries out public functions to such an extent that the establishment clause would kick in and you wouldn't be able to teach religion at one of these schools, which is obviously what this Catholic charter school wants to do. And I think there's a strong case, 4 justices agreed with it, that a charter school is neither the government itself nor such a close arm of the government that government action should be attributed to it. After all, in this Oklahoma case, the charter school is founded entirely by the Catholic Church. There are no public appointed directors. They have bylaws and articles of incorporation that are done solely by the church. The only government relationship is the contract that they enter into. And private organizations, including religious organizations, enter into contracts with the government all the time without becoming the government, to operate prisons, to operate homeless shelters, to do foster and adoption care. There's innumerable examples of that. And so it's hard for us to know where the 4 who ruled against the charter school got hung up, but I think it might have been because the statute itself denominated them public. Now, under the Supreme Court's precedent, statutory labels aren't supposed to control the outcome of a First Amendment analysis. You should look at what's actually happening on the ground, and where you have a contract but you don't have government control, that should be dispositive. But that could have been the hang-up. And so I think what we're going to see in the next few years is states amending their statutes to take that word public out of the charter schools, even though they're publicly funded, they're not public entities. And we'll see other religious schools apply for these programs and try to go through jumping through the same hoops. We know for sure there are 4 justices that would have ruled in favor of the Oklahoma charter school, even with the word public in the statute. So it all comes down to Justice Barrett in a case where she is not recused, to see if not having the word public would be enough to get her to join those other 4 and have a majority. Obviously, that would be an absolute revolution in public school funding, well, charter school funding, allowing religious schools to participate. It does raise risks, too, because if you're a school that's taking any government money at all, then the government can always attach strings to that. That's why Hillsdale doesn't take any money, even from the federal government. And so even many peoples of faith have said, I'm not sure that these religious charter schools are such a great idea. Do I want to do that? Well, in a red state where you've got a government that's not going to impose all kinds of crazy strings on these things, you probably don't worry. In a state like Michigan, that's a big concern. And so you have then this parallel question about whether when you operate under state law, a religious organization has to follow all of the state rules. And that allows me to then shift from the Supreme Court to the state of Michigan, where we have 2 of those cases pending right now here in the Western District. And those are on behalf of Sacred Heart Catholic School, which is right in Grand Rapids, and Christian Healthcare Center. And it's 2 very different clients, but they have similar problems with the Elliott-Larsen Civil Rights Act. As you recall, a few years ago, the Michigan Supreme Court adopted the Bostick reasoning, which we can discuss that in the Q&A if you want, and I'll explain why it doesn't make any sense. But nonetheless, they did that, and they said that the prohibition on sex discrimination in Michigan law extends to gender identity and sexual orientation. And then the Michigan legislature, to put a bow on that, affirmatively adopted that through legislation. And although there were several members of the House and the Senate who proposed religious exemption language to add to the statutes in addition to this statutory change, it was defeated by the majority in both the House and the Senate. So now we sit with this statute with those provisions in it and no religious exemptions for anyone. Just so you know, that's highly unusual. I'm not even aware of another state that by statute has those kinds of provisions in employment law and education and other places without any religious exemption. There's one other state, Washington State, where they basically took the religious exemption away by state Supreme Court ruling, and we can have a fun discussion about that too. But highly unusual that the state would not recognize that, because it creates immediate problems for religious entities like Sacred Heart and Christian Healthcare Center. And Sacred Heart, for example, if they wanted to take St. Pope John Paul II's theology of the body, which says that God's gift to every person is maleness or femaleness, and that's not something that can be changed. And if they wanted to put that on their website, then arguably that violates the welcoming clause in the education provisions of Elliott-Larsen Civil Rights. If they wanted to have a class field trip that had an overnight component, and they wouldn't allow a boy who identified as a girl to sleep in a same hotel room with the girls, that would violate the Elliott-Larsen Civil Rights Act. If they had a sports team and they didn't want to allow a boy to participate on the girls' team because he identifies as female, that would violate the Elliott-Larsen Civil Rights Act. And then parallel issues then for this Christian Healthcare Center. These are doctors who also believe that God created us male and female. And so they will serve anybody. Any person who comes in, even if they identify as transgender, will get medical care from them. And it's a great organization. They provide low-cost medical care to people who can't afford insurance. But they won't use preferred pronouns, and they won't prescribe gender changing drugs like puberty blockers and cross-sex hormones, the same things that were at issue in this Germetti case. And they would never refer someone to have a surgery to try to change their body to allow their body to look more like the gender that they think that they are instead of their biological sex. All of those things, too, violate the Elliott Larson Civil Rights Act. And so when the lawsuits were first brought a couple of years ago, the Attorney General's office's defense to those was, well, we need specific facts before we can say whether any of these things violate the act or not, even though the standard for standing is that they arguably violate the act, and these things all clearly do. But Judge Beckering here in the Western District of Michigan, without oral argument, just on the briefs, dismissed both cases, as well as a third case involving a Catholic school in Lansing that the Beckett Fund for Religious Liberty brought. And so those went up to the Sixth Circuit, and I think it's roughly a year or so ago now, we got the opinion from the Sixth Circuit that reinstated both the Sacred Heart and the Catholic Health Center cases. Unfortunately, the Lansing school case didn't make it. But now these cases are going through discovery, and there's going to be dispositive briefing, and likely a decision by the end of the year. And if you think about how these types of cases will play out as they go up the chain to the Sixth Circuit and possibly to the Supreme Court, they could actually dovetail with some of those concerns in the school context if we're successful with these cases. Because if the state of Michigan can't enforce these onerous new laws against a Catholic school because that violates their religious belief in this context, it shouldn't matter that they're getting funding from the state. The state shouldn't be able to attach unconstitutional strings as a condition to participate in the charter school program either. So long term, I think if there is a day where we see religious charter schools, that's the potential solution to that problem. Another religious liberty and parental right case that's pending here in the Western District of Michigan that we brought about 18 months ago involves the Rockford Public Schools. And this is another one in the gender ideology space, and it's a problem that is permeating public schools across the United States, and that's secret transitions, where a child, say that they're 13, 14 years old, and they announce to a counselor or a teacher, often in invitation to a question, well, how do you identify as your gender? That they're a gender different than their sex, that the school will help them socially transition by changing their name, changing their pronouns, giving them access to the opposite sexes, locker rooms and showers, sports teams, overnight accommodations, all those types of things, but not telling the parents, keeping a secret. In Rockford, they went so far as to have all the school records using the preferred pronoun of the child who was at school, and then changing all those records to put their natal sex pronouns in those documents so that the parents wouldn't suspect what was going on. And after many months of this and seeing all kinds of deleterious effects in their daughter's mental health, one day they got a letter home and they forgot to make the change. And they saw that they were referring to their daughter as a he. And so they immediately went into the school and demanded to know what was going on. And it turns out that the school has this policy of not only encouraging kids to transition if they identify as a gender different than their sex, but not telling the parents unless the child gives permission to do that. Well, how many teenagers who want to identify as a different sex are going to say, oh yeah, please tell my parents about this? That happens very rarely. And the worst thing about these policies is that the mule run of them are not in writing. So if you were a parent and you went to the school website, you would never see that policy. If you attended every single school board meeting, you would not see them adopt that policy. But the organizations that give counsel to public school boards advise them to do this not in writing as an informal policy so that parents of children won't know about it. And so you can imagine the religious liberty as well as parental rights claims that arise in a case like that. So there are probably, I want to say 3 or 4 dozen of these types of cases pending around the country. One that was recently denied by the First Circuit will be taking up on a cert petition to the court. That petition will be filed in July. The court will conference it for the first time most likely in early October. And so it's possible that we could get a secret transition case there. Now, on the one hand, the Supreme Court rarely takes cases that are the first of their kind. They wait for a case to percolate, so you have lots of federal circuits which are in disagreement. But they didn't do that with the charter school case, and they may not do that with this case either because it's so serious. The reasoning of the First Circuit is so bizarre in some respects. First, they said that when you do a social transition at school, that's not an act of mental health for the student, which on its face is ridiculous, because all the proponents of gender ideology would say absolutely is this not only mental health and medical health, but it's required in order to save the child, which we know all these European studies say is false, but nonetheless that would be their claim. But even more remarkable, on the parental rights side, the court said that parents only have the right not to be made to do something, or their children to be made to do something that they don't want, but not to be informed about stuff that's happening to their child. So think about it this way. If your child was being forced to pledge their allegiance to the flag or make a prayer or something like that, the parents would have the right to find that out because the child is being forced to do something. But the example the First Circuit used is, well, if the school gave them a brochure about how to be a bricklayer, and then they chose to become a bricklayer, then that's on the student, and so the parents don't get to know that. But then you start to think about the ramifications of that. That means that the school could hand out pornography to teenagers and encourage them to be sexually active, encourage them to have contraception, even give them the contraception. And as long as the child is making the choice to do all those things, then the parents don't have any right to know that. I don't think the U.S. Supreme Court is going to be super excited about the ramifications of a holding like that. And especially with so many of these cases already percolating, there's a reason for them to kind of nip it in the bud and do something with it. And a couple of the justices have already signaled that they want to hear it. There was a similar case that was brought up on a petition that had been dismissed on standing, whereas this one is on the merits. And even in the standing context, Justices Alito and Thomas dissented from the denial of cert and said these issues are far too important. It's pending in dozens of places. We need to address this soon. So that's kind of the lay of the land of the most important religious liberty cases happening right here in Michigan, as well as at the U.S. Supreme Court. At this point, I'm happy to open it up to discussion and questions, and feel free to bring up whatever you'd like.
You touched on it in your discussion of Scrimeti. If I understand correctly, the court kind of punted on the Bostic aspects of the case. I was just curious to know if you had any thoughts on, tell us anything about where that's drifting, because I feel like Justice Gorsuch and to a lesser extent Chief Justice Roberts painted themselves into a bit of a corner on how, for example, Title IX will be interpreted when the lawsuits that relate to natal males participating in women's athletics, for example. I've been wondering how they will pull that rabbit out of their hat when that comes.
We're going to have a chance to see what they think hopefully soon, because I'll be filing supplemental briefs in two of the athletic cases, BPJ and Peacocks out of the 4th and 9th Circuit, probably tomorrow, in the hopes that the Supreme Court will take the athletic cases next term. The BPJ case in the 4th Circuit was decided on Title IX grounds. The Hecox case in the 9th Circuit was decided on equal protection grounds, both in favor of the plaintiffs. And so this would be an ideal opportunity for the court to resolve some of those questions. So the way that I think about Bostock is that it all hinged on that because of language, and you don't find that language in the Equal Protection Clause or in Title IX. So if you wanted to distinguish those textually, that would be an easy way for them to put those aside. But they didn't do that in the Scrimeti opinion that came out today. What they said was that Bostock was a Title VII case. We did not take any position how that Bostock reasoning applies outside of the Title VII case then, nor do we do so today. So they've left it a blank slate. What they used was kind of the comparator analysis in Bostock, and they said it didn't apply in the context of Scrimeti. So just briefly, this is what they said. In Bostock, they said if you would hire someone, a male who was attracted to females, but you wouldn't hire a male who was attracted to males. I'm sorry, other way around. If you would hire a female who was attracted to males, but not a male who was attracted to males, the only thing that's changed is their sex. And what they clarified today, to try to push that to the side a little bit, is that when you change someone's sex, assuming that their sexual orientation remains the same, then that automatically changes too, from heterosexual to homosexual, same sex. That's not true in the context of the medical procedures in Scrimeti. So if you have a girl who has a medical condition, say she's got precocious puberty, and she actually needs puberty-blocking drugs, and then you change her to a male, and he wants puberty-blocking drugs, but he wants it for the purpose of not going through puberty so he can potentially transition to a female. There, you have not kept the medical diagnosis the same. The purpose of the treatment is different. And so Roberts wrote the opinion. He distinguished it on that basis. Interestingly, Justice Gorsuch asked no questions during the oral argument. That may be the only time that's happened this entire term. Maybe the only time that's happened the entire time he's been on the court. He's a very active questioner. But didn't ask any questions, and he didn't write any concurring opinion. So we don't know what he's thinking about all this. But it was on that narrow ground that when you're doing that comparator analysis, it looks different in the medical context than it does in the employment context that allowed them to get there without answering any of the deeper questions. Now, that kind of reasoning perhaps could be applied to sports too. If you think about a girl who's allowed to be on the sports team and a boy who's allowed to be on the sports team, the underlying thing, if you want to think about it like the medical diagnosis, would be their physical bodies. And even though the boy changes from identifying as a boy to a girl, unlike with the sexual orientation where there's an automatic change that goes with it, his body doesn't change. If he's gone through puberty, even if he's taking testosterone suppressors, he still has natural physical abilities in the way that he runs and jumps and his strength and all those other things that will not change no matter how much he reduces his testosterone, no matter how he identifies. And so it's possible that in the Title IX context they could resolve it that way. I think a better way to do it would just be to look at the plain language of Title IX and say because it doesn't have the because of language that you can distinguish it on that basis. But that's all still up in there. Or overrule Boston. But just to get out, one small pet peeve about Bostic, because I argued.
I'm sorry to interrupt.
Yeah, no, anytime. I argued the transgender portion of Bostic at the Supreme Court, the Harris Funeral Homes case. And the way we litigated the case all the way up the chain looked more like Scrimeti or these sports cases that we're talking about. It wasn't that the funeral home owner fired the funeral home director because he was now identifying as female. It wasn't a status decision. It was because he was concerned that male-female director in women's clothing would make it very difficult for their grieving clients to be able to process what they were going through after a loved one had just died. And then a subsidiary concern about him using the women's restroom with his female employees. And yet when you read the Bostic opinion, the majority opinion says that this case doesn't have anything to do with dress codes or bathrooms or anything like that. It's just about pure status discrimination. Well, that's not how the case was litigated below or in the merits briefing or at the oral argument. So the case transformed between the argument and the opinion in order to reach that result. So I have lots of thoughts about that I won't share because this is being publicly recorded. But that was a little frustrating. And we could talk about the reasoning too, which I think is just absolutely blown up by Justice Alito's dissent in that case, where he describes the majority's opinion as sailing under the false flag of textualism, which is absolutely true. But at least in Scrimeti now, we've got one indication that perhaps it could be cabined to Title VII hiring and firing decisions, and that maybe it won't sneak into Equal Protection Clause or Title IX jurisprudence. Time will tell. Yes, sir.
A few questions, you can ignore any of them if you like. One, I would just like to know over under on the forces of announcing his position in crosstalk. Two, in the Little Charter School case, was the argument made that the First Amendment establishment clause was not appropriate against the states? I've always said that's a strong argument. I don't know if it's made. Three, I'd just be curious briefly, like why you care so much about these issues. And what's my last one? I forgot my last one.
Well, three-part question's pretty good. On the first one, I don't think that Justice Gorsuch is likely to reverse Bostic. Anything is possible, but I don't see that happening. I think the more likely fix would be for Congress and the President to amend the statute and make it clear what they mean by sex discrimination. But Scrimeti demonstrates that he may be willing to cabinet to that context, and so it won't have the effect that the Biden administration was pushing, which is that the Bostic reasoning applies to every time the word sex appears anywhere in the federal code. I don't think he's going to go along with that. We talked about a lot of the likely ramifications of redefining sex discrimination in the Bostic case itself and predicted all this other stuff that was going to happen. And I think he may have underestimated how much certain people would take that and how strongly they would advocate to rewrite sex everywhere that appears to mean sexual orientation and gender identity. And so that may be the reason that he's willing to cabinet. But I don't have an over-under, time will tell on that. The second one was...
How do you think to be so passionate?
I thought that was number 3.
The second one was incorporation of the...
Oh yeah, so I love the incorporation argument, but it wasn't made, we didn't make it in the Drummond case because there's only one justice who's willing to sign on to that right now, and that's Justice Thomas. But if you look at the historical record, he's absolutely right because we had religiously founded governments in our states at the time that the Establishment Clause was enacted, and there's nothing in the enacting history of the 14th Amendment that would suggest they were intending to reverse that. You can't have a Quaker state in Pennsylvania if the Establishment Clause prevents governments from having religion.
And unlike the rest, it expressly says Congress shall make.
Right, exactly.
Do we know that all the other officers and others? I know Justice Thomas is on record, but we know the others.
Yes, we don't know Justice Barrett because she hasn't been there for a case where the issue was raised, but all the rest of them have been there in cases where Justice Thomas wrote a full-throated consent or concurrence or dissent on that, and no other justice joined them. So I'm not seeing an appetite to address that, and the Establishment Clause and free exercise issues that we had in Drummond were heady enough that adding that one to the mix if we didn't think it was going to go anywhere was just too much of a lift. But I hope people continue to bring that because I think over the long haul that Justice Thomas's belief could be vindicated. As for me, how I got here, totally God. I graduated from Western Michigan University, as you know, not a bastion of religion or conservatism even back in 1994. Same with the University of Minnesota Law School in 1997. After my clerkship, I started working at Warner Norcross and Judd, great firm here in Grand Rapids, but they weren't doing religious liberty work. So nothing about the way I started would suggest that someday I'd be spending my time, full-time, litigating these types of cases at the court's highest level. The full answer to your question would probably take about an hour, but the narrow question is that God kept opening doors for me to walk through. And each time it was a challenge where our family was forced to give up something that was really good, the bird that we had in hand, to follow what we thought he was asking our family to do. So first that was to leave Warner Norcross and Judd to become the Michigan Solicitor General. That meant commuting to Lansing an hour each way. It meant a 70% pay cut after, as a third or fourth year partner, we had just bought a new house for our 5 kids. It actually meant more hours than at Warner Norcross and Judd, which is hard to believe, but it was a busy time. You might remember that was the conclusion of the lost decade here in Michigan. The legislature and the governor were signing all kinds of bills into law that were going to change the climate here in Michigan, and we were getting sued over all of them and successfully defended almost everything in the state and federal courts. But the family decided that was what God was calling us to do. And it was during that time that I had the honor of representing Michigan in the U.S. Supreme Court 8 times. So that kind of gave me the Supreme Court bona fides. Well, after I went back to Warner Norcross and Judd, I thought I'd retire from there, but they had adopted a controversial matter policy, and that implicated when I was asked to argue Obergefell at the firm. I had to do that on my own time on nights and weekends as a special assistant attorney general. And then impacted me again when we got requests from the North Carolina governor's office to defend their bathroom bill, and from the Nebraska attorney general, who was challenging with 9 other states the Obama administration's reinterpretation of Title IX. And the firm turned down those matters, and so that's when I went out and set up my own shingle, gave up the security of the paycheck, the prominence of this big, really successful law firm, and an appellate practice that I'd worked years to build there. But we felt that God was calling me to do something more, and it was clear that these types of cases were not conducive at a business law firm which had clients on both sides of these issues. Not to overly criticize Warner Norcross, because they were getting all kinds of pushback from clients who didn't want those kinds of cases being litigated by their lawyers. And just to show God's faithfulness, the very first case that I got at Bursch Law, I opened the doors on Monday. On Tuesday, the Indiana Attorney General's office called and asked me to take the lead defending their bill that prohibited the sale or transfer of aborted fetal body parts and tissue. And so that was that. And so then I started helping Alliance Defending Freedom as an allied attorney. And I would urge all of you to consider signing up for the Allied Network if that's something you haven't done. We have about 5,100 attorneys across the country who do pro bono work or sometimes for small grants and pick up the religious liberty free speech cases that we don't have capacity for with the folks who are on staff. And specifically, they wanted me to help with Supreme Court cases. And so I helped with 2 of their cases, Masterpiece Cake Shop and NIFLA. And at the conclusion of the NIFLA case, I'm probably going into more detail than you wanted to hear, but this is a fun part of the story. I was going to be headed back to Michigan, and there was an inch of snow in DC, and the airport closed. And so I had to stay overnight, and I called my wife with my tail between my legs, told her I'm not going to be coming home, and she said, well, I'm sure God has a good reason for you to be in DC an extra day. And the next day I had lunch with Kristen Wagner, now the CEO at ADF, then she was the chief legal counsel, and she asked if I would come aboard and start an appellate and Supreme Court team at ADF that didn't previously exist. And so that meant giving up Bursch Law and a lot of those freedoms, but it was an easy choice at that point to me. So it was just like one step after another. God said, okay, this is next, this is next. I'm not going to make this so hard for you where you have to go from point A to point Z. I'll give you some baby steps along the way. But as a family, it was discussing things, even with our young children. You know, as young as 5 or 6, they were part of the family discussions, because if you're talking about a 70% pay cut, that impacts the entire family. You know, she wanted to know where the ice cream budget was going to come from. But seriously, you're talking to the family about it, praying about it, and always trying to do God's will. And one of the things that I'm really proud of, not any of the legal accomplishments, not any of the stuff that I'm working on, but the way our 5 kids have grown in their faith and followed that same notion that they should be doing what God wants instead of what they want. None of them are lawyers. People ask me that all the time. Are your kids going to be in the Supreme Court? No. We've got a pediatric oncologist, a sacred architect who designs churches, a music therapist who works with kids in hospice and long-term palliative care, a nuclear physicist, and a daughter who will someday be teaching sacred music to high school choirs. And each one of them was totally convinced that that was what God was asking them to do. That was the talent and the interest that he had given them. And so I guess the biggest takeaway I'd have for all of you and your own families, this has nothing to do with religious liberty law, is to take your faith seriously when it comes to your kids and the values that you're communicating to them. And that faith isn't just something that we do when we pray before a meal or if we go to a mass or a service on Sundays, but it's something that we live in everything that we do, including the choices that we make when we get married and when we have children and the jobs that we take, even the colleges that we attend. And so the choices that we made as a family to help get me to this point had a huge impact on my children.
I'm so glad you asked that.
Yes. John, you've got to go.
What time is it?
It's 1:03.
The interview's at 1:45.
Okay.
Yeah, we're totally good.
Don't want to peak too early. Right?
I'm talking to Nina Totenberg on NPR at 1:45 about the Scrimeti case. So there's time for more questions if you guys want to keep going.
I asked one, I'll give you another one. Is there anything in the state courts? I know you mostly talked about federal. I don't know if there's anything in the state judiciary or the Michigan Supreme Court or percolating that is something on your radar.
The supposition is that religious liberty is probably not going to be looked on very favorably at our state Supreme Court right now, given its current composition. So it's not a coincidence that every religious liberty case is pending in Michigan federal courts, not in state court. And so the big battle is to file these pre-enforcement lawsuits like CHC and Sacred Heart and try to get the federal courts to recognize that they have to address these constitutional issues first. And you can't underestimate how important that can be. There's another case that we just had our cert petition granted this past Monday, not in the religious liberty context, but in the pro-life context. It's on behalf of First Choice, and they've got pregnancy centers pro-life pregnancy centers in New Jersey. And in New Jersey, the Attorney General, like in a lot of states right now, they're doing everything that they can to persecute these pro-life centers. And you would think that these blue AGs would all be about choice for the women. I mean, that's their messaging, right? But it turns out that only one choice is permissible. And so if anyone is trying to help someone keep a baby or to raise the baby, they're going to do everything they can to make their life miserable. Like Governor Whitmer did here in Michigan when she vetoed $30 million in funding to help women who want to choose to keep their babies. That's not offering choice. That's offering a one-way road to taking children's lives. So what these attorney generals will do is they'll find some reason to investigate. It's different in every state. Sometimes it's because a pregnancy resource center promotes abortion pill reversal. In New Jersey, he said they're possibly misleading donors. What he said was, folks who donate to First Choice, this pro-life pregnancy resource center, might not know that they're pro-life and that they don't do abortions. That they're fraudulent in the way that they advertise who they are and what they do, which on its face is absolutely absurd. But because there's a risk of that, I don't have any reports of anyone being defrauded, nothing has been reported, I'm going to issue a subpoena, and I want your 5,000 top donors. Well, we all know, after Americans for Prosperity and the Thomas More Law Center case, which was an ADF case, the Supreme Court has said that AGs can't demand donor information like that. You simply can't. So this is unconstitutional. And so we see this happening to other pregnancy centers in New Jersey, and immediately file a federal lawsuit. And the federal district court judge says, well, until the subpoena is enforced, there's no standing to come to federal court. And our argument is, well, once it's enforced, you've got a ruling on the constitutional issues at the state court. Now we're going to the New Jersey Supreme Court instead of having this litigated in the federal courts. And the Third Circuit agrees with the district court. And fortunately, the U.S. Supreme Court decided to take that case. And the issue presented is whether you have to wait for a subpoena to actually be enforced, or whether simply the threat of enforcement is enough to have your constitutional issues, your challenges to that subpoena or CID or whatever it happens to be analyzed and decided by a federal judge. So you'll see these types of things come up in all kinds of different scenarios, but it's crucial.
So you just mentioned abortion pill reversal.
Yes.
Is it on your radar at all, or have you heard of maybe licensed health professionals like doctors who are promoting that they do abortion pill reversals or actually promoting them? Have you seen an uptick in persecution against them?
Yes, absolutely. And here in Michigan, there were 2 doctors who were affiliated with pregnancy resource centers, and they were available to promote and talk about abortion pill reversal with clients. And Attorney General Nessel investigated both of them for violating Michigan consumer protection law by falsely telling people that this could be an effective treatment. Now, the science on abortion pill reversal is in a state of flux. There's medical professionals on both sides, kind of the way there is with the Americans versus the Europeans in the gender context. But some of the science is actually pretty good. There is no study anywhere that would show, and maybe I should back up a second and talk about what abortion pill reversal is for those who don't know. If someone is having an abortion and they're doing it chemically, they take a 2-drug cocktail, mifepristone, and that's followed by mifepristol. And if someone takes the mifepristone and they have a change of heart and they decide they want to keep their baby, the best treatment that we have for that is to give them, we call it abortion pill reversal, but what it is a massive dose of progesterone. And what the progesterone does is it attaches to the receptors that the mifepristone would ordinarily attach to, and so it can stop the effects of the mifepristone. But it has to be done quickly, within a couple of days after they've taken the mifepristone, and then of course you don't take the mifepristol, which would actually start the process of expelling the dead baby from the womb. So there is no study anywhere that shows that trying the abortion pill reversal by giving them the progesterone causes any harm. And there are numerous studies that show that anywhere between, say, 63 and 80% of people who take the progesterone are successful in preserving their baby's life. And there are, dozens, probably hundreds of examples across the country of babies who grew up and they're flourishing toddlers and elementary schoolers today because of these pills. But yet, because of the blue AGs who are persecuting pro-life centers, this was one place where they were able to go after people. Now, in both of those cases, the Attorney General did not end up pressing any charges after an investigation. I don't know what she was thinking, but that was the end of those. But in other states, we're seeing doctors lose their licenses. We're seeing the pregnancy resource centers sued under these consumer protection laws, all because they're encouraging women to try this if they have a change of mind. And again, it's this one choice mentality. Like, you can only choose abortion, and if you change your mind, we're not going to allow you to do that, even though there's good medical science that says that this could save your baby, and at a minimum, it's not going to harm it. It's really horrible.
Just to stay on this topic, you were talking about some of the pregnancy resource centers, and one of the issues that we're seeing north of the border in Canada is the phrase dishonest counseling. That's been specifically raised by the federal government in an effort to potentially pull charitable status from pregnancy resource centers, where it was found, again, based on their representations, that they were providing dishonest counseling. Are you seeing, it sounds like we're seeing some of those similar themes in the US right now as well.
We are, and it's interesting that in Canada there's threatening the nonprofit status, because I have not seen that in the United States yet. But what we are seeing are the consumer protection laws saying that they're engaged in fraud when they have an ad that pops up on the internet when someone is searching for pregnancy stuff, and the language that they use, they say misleads people into thinking that they will provide abortions when they actually don't. And so there are numerous states that have filed lawsuits like that. Those are being actively litigated. And companies like Google, using that same reasoning, are suppressing the search results and canceling ads for pregnancy centers who have perfectly legitimate advertising about the pro-life services that they do provide. And so these are sham prosecutions, just like that's a sham attempt to take away nonprofit licenses. But that's not going to be far around the corner. And we know that on some of the LGBT issues, taking away tax exemptions is on the table there too. If you go back to Obergefell, it's taking a little bit longer than I may have predicted, but the justices asked Don Verrilli, the U.S. Solicitor General, if there's an organization, a nonprofit, that won't get on board with same-sex marriage, could their nonprofit law be at stake? And he said yes. He was candid about that. Don was a straight shooter. And so while I'm not seeing a rush to do that, I'm seeing religious organizations persecuted in so many other ways, from employment to education to whatever, that it won't be long before someone tries to take away nonprofit designations for religious organizations that won't get on board with that.
You briefly touched on Google. We see a lot of these platforms are more of an editor than they
Yes.
are an actual platform. And not that this is really religious liberty based, but is there anything you see on the horizon about looking at these social media content, these social media distributors? And that's the marketplace of ideas. That's got to be highly protected. Obviously, a lot of people like religious things are shadow banned and they're forced down to the bottom. What do you see on?
Yeah, that's something that we're working on as hard as anything right now, because
Okay.
it's a really tough nut to crack.
Yeah.
Because if you go to a content, not creator, but aggregator, like any of the social media things, they'll make the exact same arguments that we make in favor of creative professionals. You can't make Jack Phillips or Lori Smith bake the cake or do the wedding website because that violates their belief. They have a free speech right to only say what they believe, and Google and Twitter and everybody else will say exactly the same thing, so it's very difficult. Now there are obviously massive differences between, say, Facebook and Jack Phillips or Lori Smith. And so using antitrust laws and other things like that, there may be ways to get at that. I think the long-term solution is probably going to be through legislation. But even that is tricky because you can't legislate in ways that will substantively regulate what they can say. You have to write the statutes in a way that will prevent them from deplatforming people in content-neutral ways.
Yes.
And so we saw 2 of those laws go up to the Supreme Court from Texas and Florida in the net choice cases, and the justices didn't really know what to do with those. And so they remanded both of them for further proceedings, basically articulated a lot of the First Amendment principles that we would all support. You can't have content and viewpoint-based speech restrictions. And then said, you figure it out and then come back. So in the meantime, our legislative team has been working to try to draft bills that will survive those types of challenges, but will prevent the social media platforms and the Googles of the world from discriminating against religious believers. Now, we've already seen a shift just since the beginning of this year when the new president was inaugurated in the way that they're talking about this stuff publicly, in dropping DEI initiatives that were being used to persecute people, and things like that. I don't know if that's going to be a long-lasting thing or if that's just politically expedient. I suspect that because they perceive it to be in their best interest right now, it's only political expediency. But there's got to be a combination of political pressure, market pressure, bills, and possibly some really, really creative lawsuits in order to crack that nut. But we formed a new team a year ago. We've always done free speech on campuses. That's been a big part of what we do. And the free speech is always a tag along with the religious liberty cases too. You think about the creative professionals. But this group is dedicated just to that issue. It's broad speech censorship by big tech. And so how do you solve that problem?
Was it that case that Justice Thomas said in a concurrence that maybe they should be treated as like common carriers?
Yes, which is one of the theories that we talk about. Yes, Thomas mentioned that in Net Choice. But again, the court didn't decide any of that.
Right.
It just simply threw out a bunch of ideas and said, you guys try first and then
I didn't hear you mention that one, but I thought that was
Yes.
common carrier.
Common carrier is another one. If you think about, well, we won't use the post office because that's government, but like Federal Express, they're an all-comers organization. All they're doing is taking letters and boxes and they're moving them to someone else. And if they discriminated against someone based on the content of what was in the box, barring it being a bomb or something like that, then they could be prosecuted for that or sued for that under just anti-discrimination laws. And so then the question becomes, are Twitter and Facebook and Instagram more like FedEx, or are they more like Lori Smith? So that's where the rubber hits the road. Really hard cases. Great question.
Okay. John, thank you so much on behalf of the section. Real pleasure having you. As always, can't hear this guy speak enough. And thank you everyone so much for coming out. We hope you enjoyed our event. And please do stay involved in the section. And if you've got an interest in making that leap and serving on our council, please reach out. We'd love to have more of you from Western Michigan. Thanks again.
Yes, and I'll just add to that plug. there's no more important time in U.S. history than right now to be promoting religious liberty.
Yeah.
I mean, even if you can't get someone to agree on the underlying issues, everyone should be able to agree that the Constitution protects everyone to live out their beliefs, not just at their church or their mosque, but in the public square. And every one of us has a responsibility, because if we don't push that, 20 years there may not be a religious liberty section in Michigan, because it would be too controversial and right-wing to be shut down. So even if you're not on the board, take a role.
Yep.
Do something.
Awesome. Thanks again.
Thank you.